Your Honor, Justice Jacobs.
That's all right. Okay, where are we on this? This is set for trial.
Right from the opening seconds of this hearing, we're stepping into a classic but high-stakes courtroom dispute. A landlord seeking eviction for unpaid rent and a tenant claiming serious maintenance issues inside the property. These cases might sound routine, but they often turn into emotional battles because housing, finances, and personal safety are all tied together. According to the landlord's attorney, this case revolves around non-payment of rent. That means the property owner believes the tenant has stopped paying entirely and is now asking the court for what's called a judgment of possession. In simple terms, that's the legal order allowing the landlord to take the property back. But there's another layer already forming beneath the surface. The tenant appears ready to argue that major repair problems existed inside the unit. Issues like leaks, mold, or unsafe living conditions can sometimes affect a tenant's obligation to pay rent under what's known as the warranty of habitability. However, these defenses only work when tenants follow very specific legal steps, reporting the issues, allowing repairs, and documenting the problems properly. So here's the tension the judge is about to explore. Was the apartment truly unlivable, or did the tenant stop paying rent while preventing the landlord from fixing the situation? As this unfolds, pay close attention to the timeline of events, because in housing cases like this, the timeline can decide the entire outcome.
Yeah, Your Honor, to refresh the court's recollection on this particular matter, this is an action for non-payment of rent. We had a trial date set for July 26th. The landlord tried to enter on July 25th and was refused entry. We came to court, all of us ready to go forward, and because we were not permitted entry, the court adjourned this to today. The court ordered that the landlord enter on the 28th and the tenant provide a list of repairs. The landlord did enter, even though the power was out on the 28th, was able to fix the garbage disposal, came back on the 31st and the 1st to conduct the other repairs. A list was given on the 28th. It's landlord's position at this point, due to the refusal for entry, that any repairs that were so important are waived, and that the list that was provided on the 28th is relevant and has been completed. It's the landlord's position that has been completed, and we're seeking a judgment of possession for the full amount of rent, which is $5,229.68.
That number, $5,229.68, is the financial core of this entire case. In eviction proceedings, the landlord must show how much rent is owed, and that total becomes the amount the court considers when deciding whether the tenant has violated the lease. In most non-payment eviction cases, the landlord only needs to establish three things: that a lease exists, that rent was due, and that rent was not paid. If those three elements are proven, the case can move very quickly toward eviction unless the tenant presents a legally valid defense. Now, the tenant appears ready to argue that serious repair issues justify withholding rent. That argument is based on the legal idea that landlords must maintain safe and livable housing. But here's the catch many tenants don't realize: withholding rent isn't automatically allowed. Courts typically expect tenants to continue paying rent or place the money into an escrow account while the dispute is resolved. If the tenant simply stops paying and spends the money instead, the court may see it as straightforward non-payment rather than a legitimate protest. So as we move forward, the judge is about to ask a crucial question: what exactly is still wrong with the apartment right now?
Yes, sir. So since we moved in April, I moved in, there was a massive shower leak, which led to the discovery of mold.
Okay, but hold on a second. I just want to go back to when we were here on the 26th.
Sure. Yes.
You didn't permit them to enter the unit.
Right. They requested to be moved at that time, which was ignored, but they had already been in the unit in June to fix said issues, and they weren't properly fixed. So they were
Okay.
a lot of
Okay. You can obviously,
Okay.
but listen,
Yeah.
you didn't let them in,
Okay.
right?
For one of them.
So then I ordered you to let them in. You let them in. You were to give them a list of things that were to be done. So let's start there. Did those get completed?
Yes.
Okay. So what are we now fighting about?
The fact that the issue was there for 3.5 months since move-in, many issues. We tried to contact them via phone, no response. We tried to contact them via portal, no response. They did come to attempt to fix the issues in June, but they weren't properly fixed according to the.
Why don't you move?
At this point, I'm just, we'll do the year and then.
Well, I mean, if it's set, why don't you just move?
I would prefer just to stay at this point, but the responsiveness of Harbor One West and all that is horrifying. They don't respond to you at all. And there's been plenty of opportunities to fix the issues and they don't.
So what is now wrong with the unit?
As of currently now, nothing, but for 3.5 months, one of the bedrooms was soaking wet.
This brief exchange may have just reshaped the entire legal argument. When the judge asks what is currently wrong with the unit, the tenant answers, nothing. That's a critical detail because housing courts focus heavily on the current condition of the property when deciding these disputes. If serious repair issues existed in the past but have now been corrected, the court often shifts attention to the financial obligations under the lease. The tenant claims the apartment had severe problems for months, possibly including water damage and mold. But if those problems have already been fixed, the judge may view the remaining issue as unpaid rent rather than unsafe housing. Then the next question comes quickly, did you pay the rent? And the answer is no. That combination, no current issues and months of unpaid rent, creates a very difficult legal position for the tenant. Because even when repair issues exist, courts expect tenants to follow strict procedures before withholding rent. So from the judge's perspective, the key question becomes whether the tenant followed those procedures or whether he simply stopped paying.
Did you pay the rent?
No.
Okay, look, here's the thing. There's how much over?
Your Honor, the total balance is $5,229. The tenant hasn't paid.
Since when?
Sorry.
Excuse me, hasn't paid since when?
Since April 17th. His move-in costs were paid, and then there's not been a payment since then.
And give me that figure again, I'm sorry.
Sure. It's $5,229.68. I did put a copy of the ledger for your.
Yes. So, sir, how much do you think you owe?
When there's mold and there's a.
I didn't ask what. I'm just saying, how much do you think you owe?
Until right now, nothing.
Seriously.
There's been mold.
You think you get 100% abatement?
Okay.
That's not going to happen.
No lessee or licensee shall be obligated to pay rent for any time periods that the lessor or licensee is in violation of this section, which is section 58-122.
58-122 of what?
The premises and all common areas
Of
of
what?
the municipal code of the city, I guess. What I was given to by legal services to reference today.
Mm-hmm.
Yes. To keep the premises in reasonable repair during the term of the lease or license. And to comply with.
Did you read the rest of that? Did you read the rest of that section?
Yes, I did.
This is a moment where courtroom reality collides with legal theory. The tenant is quoting a section of municipal housing code that supposedly supports his argument about unsafe living conditions. But the judge immediately asks whether he read the rest of the statute, and the answer reveals that he only reviewed part of it. That's a serious problem. Legal statutes are rarely simple one-line rules. They usually contain multiple conditions, exceptions, and cross-references to other sections of law. Judges expect anyone invoking a law in court to understand the entire provision, not just the part that seems helpful to their argument. The judge even asks whether the tenant reviewed related sections dealing with certificates of occupancy, another critical element in housing law. When the tenant admits he didn't, the judge's reaction says everything. This moment demonstrates one of the biggest challenges for people representing themselves in court. Legal arguments must be complete and precise. Otherwise, the judge may quickly dismantle them.
You read the whole 58, the whole section?
No, I just read.
Did you refer to the other sections that refers to regarding a certificate of occupancy?
No.
Didn't think you did.
They weren't in compliance for over a month. I mean, I guess I don't understand.
No, I can tell.
Okay.
You gave me one section of a statute or an ordinance.
Okay.
Give me the other sections.
I don't have the other sections, Your Honor.
I didn't think so. Why don't you have the other section?
I wasn't provided them. I was speaking to legal services about this matter over and over again, and they provided me the situations or the
You want to go call them now, see if you can get the other sections? Because you're just quoting half stuff to me.
Okay.
You want to?
No, Your Honor.
So we can get rid of that. The COC on this building was issued when?
West was the earliest.
I know.
It was,
That had to be in February.
I believe it was in February, Your Honor. It was
And-
long before the defendant took possession of the unit.
So do you understand why what you just read doesn't apply for you?
Yes, because they have certain, yes. I just don't understand why, if there's mold that's making me sick, that I've had to go to the doctor.
Do you have medical?
Yes.
Was the medical, well, okay. My goodness, look, you can't give me hearsay statements.
These are medical documents from the office visit for this mold issue, which I've emailed to.
They're hearsay.
Okay. Okay.
Your Honor, if a tenant has severe repair issues, which he claims, and mold issues, and then he refuses to let the landlord in, it just doesn't make any sense.
This statement from the landlord's attorney highlights what may be the most damaging fact for the tenant's case. Under housing law, landlords must fix serious repair issues once they are notified. But tenants must also cooperate with those repairs. That cooperation includes allowing the landlord reasonable access to the property. If a landlord shows up to repair something and the tenant refuses entry, courts often interpret that as the tenant preventing the repair from happening. And once that occurs, it becomes extremely difficult for the tenant to claim the landlord ignored the problem. This is why the timeline matters so much here. The landlord claims they attempted to enter the unit the day before trial, but were refused entry. If the judge believes that happened, it significantly weakens the tenant's defense, because legally speaking, a tenant cannot complain about repairs while simultaneously blocking the people responsible for fixing them.
And I maintain he's indicated that has been fixed. He had a city violation that was dismissed when I mean, I'm not sure what we're even arguing about. We would be more than happy to let this defendant vacate the premises and let him out of his lease.
If the previous, the escrow and the initial rent is given back in court.
Well, we would have a very good question. Because he moved in and hasn't paid us.
How many times are you not given access to the premises based upon the repairs? Yeah,
I believe one.
sir, that's part of the problem here. And you're going to be going out of the world backwards on this because you can't say I have repair issues. Can't say they won't respond and then deny them access.
But that was the most recent time. I did not deny them access when they came back in June to fix the issue from the complaint to the city. They came to, they obviously came, said they fixed the issues and they didn't fix the issues.
Your Honor, not to litigate this right now, but we were notified, we thought we fixed the issues. And then the next time when we went back, when we're told that we hadn't, even though the city didn't think there was an issue, we still went back pursuant to having trial the next day and were refused. So this has not been ignored.
It was for.
What do you want?
At this point, I would feel comfortable paying rent from the point now, or at least Monday, Tuesday.
You can't do that.
Okay.
I mean,
I don't.
you denied them access. A tenant can't say there's a problem. and then deny them access.
Okay.
Eh,
And when we had the issue the first time, we did not deny access. They came, they made their repairs, but they did not actually repair the issues. 2 days later, the city inspector came back and found them in failure to comply. I have that report.
Which, just for the record, the landlord did not receive a copy of.
I don't think that's on me. That would be on the city.
You are simply amazing.
Okay.
Ms. Cunningham, anything you want to say?
Tons, but no, thank you.
No, go ahead. So, were there points in time where either of you could not reside in the unit?
Yes. Myself.
Did you go someplace else? Pardon?
I made other arrangements, yeah.
Just you or
Just-
both of you? Oh,
Initially, when he moved in, I was to come shortly thereafter, and then when I was helping him, I actually did tell him, and we have a witness that I said it smells like mold in here, and the floor's wet in the second bedroom.
okay.
No,
Did you move in then, or what did you do?
I have issues when I go to his house. I can't go there. I have autoimmune issues.
I have also.
I wasn't talking to you.
Okay, that's nice.
You know what, young man? I'm going to tell you one thing right now, and I'm going to tell you, you better check yourself. So I'm going to give you a minute to go out into the hallway. Otherwise, what's going to end up happening is you're going to be in contempt.
This moment shifts the atmosphere in the courtroom. Courtrooms operate under strict rules of conduct, and interrupting the judge, especially repeatedly, can quickly lead to serious consequences. Here, the judge warns the tenant that he's approaching contempt of court, which could result in fines or even temporary detention if behavior continues. But beyond the procedural issue, this moment also affects how the judge perceives the tenant. Judges often evaluate not only the legal arguments presented, but also the credibility and demeanor of the people involved. When someone appears confrontational or dismissive of courtroom protocol, it can undermine their position, even if some of their arguments have merit. By ordering the tenant to step outside the courtroom temporarily, and the judge is restoring order and making it clear that the hearing will proceed under strict rules. Now the judge turns to Ms. Cunningham, whose testimony may provide additional context about the living conditions inside the apartment.
I was talking to Ms. Cunningham. I wasn't addressing you. I don't know why you felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now. Right now. And when you feel like you can behave yourself, then you can come back in. Ms. Cunningham, you were saying.
No, I made other arrangements because I have autoimmune issues. The plan was, but because there were issues at the apartment, I couldn't move. Arrangements have been made.
So you stayed someplace else.
Yes, I plan on staying somewhere else as well.
Okay, are you currently staying someplace else? Are you paying rent elsewhere?
I am.
Okay. So you have another unit that you rented or what? I mean,
No, I'm staying with family.
gotcha. So Ms. Cunningham, let me ask you this. If you have autoimmune issues, I get it. And that there's a place where you can't stay. Why would you want to be obligated to this lease? I guess. I mean, I'm just talking for you. I'm not.
This is an important strategic question from the judge. Ms. Cunningham has just explained that she has autoimmune health issues and suspects mold inside the apartment. If those concerns are legitimate, the judge is wondering why anyone would want to remain legally tied to the property. From a legal standpoint, tenants who believe a property is unsafe usually seek to terminate the lease or relocate. But here, the situation appears more complicated. Ms. Cunningham explains that she has alternative places to stay, but the tenant, Mr. Jenkins, may not. That introduces a very real human element to the case. Housing disputes are rarely just about contracts and statutes. They often involve financial limitations, personal circumstances, and a lack of available alternatives. The judge seems to recognize that reality and begins shifting the conversation toward a practical solution rather than a purely legal one.
I support Mr. Jenkins in the sense that I have people that I can stay with. I have other opportunities. It wasn't hard for me to find somewhere else to go. I don't know Mr. Jenkins' situation, which is why initially we entered into living together, because he did that and it worked. So I have options. I don't believe he does. So I guess it's one of those, it is what it is situations, for lack of a better term.
So I guess, Ms. Cunningham, do you want to be obligated on this lease?
I mean, ideally, no, but without sounding disrespectful, I would like my friend to live somewhere that's safe for him. And the fact that he doesn't have other options, I would hope that he could live there safely. I mean, I guess I would ask the court and everybody in the court, would you want your family living there?
Ma'am, I don't know. I'm just asking.
I'm just saying, no, I mean, I don't know. I don't have an answer to that. The answer is I support him. I have options. He does not. If this is the way that it has to be, then this is the way it has to be. But no, I would not, which is why I didn't.
So if other options were presented to her, right? All right. I think I got it. Mr. Jenkins,
Yes, Your Honor.
if I go through this whole trial, don't just find in plaintiff's favor, and you have to pay $5,000 plus in 10 days. Are you going to be able to do that?
I would not.
So, can in part, we kind of really boil this down to what it is. Okay. Because the way that you're proceeding on this right now, you're going to lose.
This is one of the most direct warnings a judge can give during a hearing. What the judge is essentially saying is that if the case continues strictly on the legal arguments presented so far, the tenant is likely to lose. And the judge explains why. Even if maintenance problems existed, the tenant's decision to deny access to the landlord severely weakens the defense. Housing courts typically expect tenants to report problems and allow repairs. Blocking entry undermines the claim that the landlord failed to fix the issues. But instead of immediately ruling against the tenant, the judge begins exploring a different path. He recognizes that eviction would likely create a much bigger crisis for the tenant, one that might not benefit anyone involved. So the judge starts steering the discussion toward a solution that could avoid that outcome.
And I have to thank Ms. Cunningham, because Ms. Cunningham gave me great insight to exactly what I think is going on here. Part of it is you really do have to fight this, because if they get the full amount of their judgment, you can't pay it. And then you're going to be out. And then the options that she talks about, regardless of the merits of the case, there aren't other options for you. Right?
Yes.
That's why you can't, when they say, just leave, we'll let you out. You can't do that, right? I mean, you could, but then you need the funds to be able to do something else.
I'm sorry.
Young man, can I just ask you a question?
Yes.
You've been before me, at least in person, 3 times. This is your 3rd time. Why don't you just say that?
I don't know, Your Honor. I just don't understand how, when there are maintenance concerns like there were, we're given plenty of opportunity, and it's just like,
Okay,
it's dismissed.
but
I don't get it.
here's the thing. They're not all dismissed. Part of the issue is getting the maintenance issues corrected.
Right.
But the problem is you made one huge mistake when you didn't let them in.
This statement sums up the legal turning point of the entire case. The judge acknowledges that repair issues may have existed, but emphasizes that refusing entry for repairs was the tenant's biggest mistake. That single decision undermines much of the legal argument about habitability. Courts expect tenants to provide landlords with a reasonable opportunity to fix problems. Without that opportunity, it becomes extremely difficult to prove that the landlord neglected their responsibilities. The judge even says that the tenant almost negated his own case. That's a powerful phrase in legal terms. It means the tenant's own actions weakened the defense he was trying to rely on. But instead of ending the discussion there, the judge continues asking questions aimed at finding a workable solution.
So you can't have maintenance issues. Landlord comes to fix them. Tenant says, I'm not letting you in, and then says, oh, I'm going to complain about these maintenance issues. It can't work that way. Okay? And then the other part of it is that, you know, I know you've been on the Zoom when I'm going through these cases. Part of the issue becomes, from my perspective, is how to keep people out. It really isn't about trying to kick people out. But one of the things that I think you should learn from that is, or should have picked up from that is, just give me the honest story, right? Okay, you can have repair issues, but the reality is, Your Honor, I can't go anywhere else. I might be struggling for this reason, that reason, whatever the reason, but here's where I am. And then try to figure out a way to make that work. Right?
Yes.
Because otherwise, the problem is, you go through this whole thing, and then you got 10 days to do something. And what? So if I told you you had to put another $2,000 into escrow, could you do that today?
Today,
Now the judge begins testing whether the tenant has any realistic ability to resolve the financial dispute. Escrow payments are often used in housing cases as a compromise. The tenant deposits money with the court or landlord while the dispute continues, showing good faith and a willingness to meet financial obligations. But when the judge asks whether the tenant can immediately place $2,000 into escrow, the answer is no. That response reveals the deeper issue driving this case: financial limitations. Without the ability to make significant payments quickly, the tenant's options become very limited in a legal dispute about unpaid rent. This is why the judge continues asking questions about income, payment plans, and possible repayment schedules.
Could you do it in 2 weeks?
Yes, sir.
Okay. So let me ask you this. Did you talk to them? I mean, so here's the thing. You're telling me a condition exists, right? But now what makes the landlord not really have to negotiate regarding that is you didn't let him in. Okay?
Yes.
And it's like with regard to most issues, the tenant doesn't report it. And the landlord, just by way of osmosis, is just supposed to know. It doesn't work that way.
I mean,
I'm not saying that's just the case. What I'm giving you examples of is, along with those repair issues, the tenants have obligations too. They have to notify the landlord. They have to make sure to provide access. They have to make sure to do all of those things, right?
and they weren't done until 2 weeks ago. I mean, I did all that. So that's where I'm just a little confused.
Right. The section they give you, at some point, that unit passed a direct health and safety inspection.
Right.
All right. Now, if something happened between then and then, okay, then it's got to be dealt with.
Right.
But the landlord has to know.
Right.
And then you have to provide access. And that's your big problem with this case. Even if, let's say, I believe everything that you tell me, right? You almost negate your own case. So let's think about the big picture. You want to stay, right?
For the remainder of the lease, yes.
All right.
This exchange reveals the tenant's ultimate goal. He wants to remain in the apartment, but staying in the unit requires resolving the unpaid rent issue. From the judge's perspective, that means figuring out how the tenant plans to catch up on thousands of dollars in arrears. Housing courts often try to avoid eviction when possible, but tenants must show a realistic plan to meet their financial obligations. So the judge pushes the tenant to explain how he intends to make up the missing payments. And that's where the conversation becomes even more revealing.
Right now, if I had to make a finding, we'd probably get everything. Okay? So if we operate just for the moment on that assumption, okay? How do you propose getting to your goal of being able to stay?
By providing the rest of the rent if it was to go in their favor.
Okay, so maybe I should have inartfully asked the question. Okay. You want to stay the rest of the lease.
Right.
Okay. You're about 3,000 some change behind, right?
Yes, sir.
How do you propose making that up so that you can accomplish your goal of staying the rest of the lease?
The next pay period, I can put at least another $1,500 in. I'm not quite sure where the over 5,000 is coming from, since we did pay the.
Hold on. Did you have a ledger?
I do, Your Honor. I'll provide it.
Okay, so go ahead.
I'm sorry. So we paid like post-dated rent for April. So that until May 1st would be May, June, and July would have been. No, legal fees. Got it. It's the legal fees and late fees that are the issues.
Yeah.
Because the rent is the 1050. And I see that now.
Okay. So how would you get yourself out?
I guess.
So let me ask you this question. If I give them a judgment for that full amount and tell you got to do something in 10 days, what do you do?
I wouldn't be able to do that, Your Honor.
Then what would happen?
I would have to be evicted.
And then where would you go?
I have to find other options, I guess.
They're not there right now, right?
Not currently. I mean, I would have to obviously start looking around, Your Honor.
Okay. All right. So of this 3,000, how do you propose? How would you make that up? I mean, how do you see making this work for you to get to where you want to be, which is to remain there the rest of your lives?
I mean, I get paid every 2 weeks. I can every 2 weeks put money towards the rent, obviously. Yeah.
Let me ask you this. How did you find yourself in this position?
By withholding the rent and spending it while these issues were there.
Yeah. Okay.
This admission is one of the most important moments in the hearing. The tenant openly acknowledges that he withheld the rent and spent the money. That confirms what the judge likely suspected earlier, that the rent was not being held aside for the dispute. From a legal standpoint, that significantly weakens the tenant's defense. Courts expect withheld rent to remain available for payment once repairs are addressed. Spending the money instead transforms the dispute into a straightforward non-payment case. But notice the judge's response. Rather than reacting harshly, he thanks the tenant for being honest. That honesty shifts the conversation toward finding a practical solution rather than delivering punishment.
Yeah. Okay. Thank you for your honesty, because I knew that's what happened. Okay. So you know something, Mr. Jenkins? I've been doing this for a long time. Right? And I don't think you're a bad person. I don't. I think you were, every time you'd walk in, you were angry. You weren't sure how to get yourself out of this. And so you just kind of puffed up. And it wasn't going to get you anywhere. Isn't this a much better conversation to have?
Yes, sir.
All right. Now, so sometimes in life we just do stupid things. Well, I don't say stupid things, but we just do ill-advised things. Like supposed to be withholding our rent, and then we spend it on something else that happens, and the next thing you know, D-Day comes, I ain't got it. Right?
Yes, sir.
Happens. How old are you?
How am I?
Yeah.
36.
Okay. You got a lot more time to make a lot of stupid decisions, so don't worry about it. Okay? They're just going to happen. Okay. Is there any room with some of the late fees that you could maybe do? I realize that you don't have to, but he wants to stay. I think if nothing else out of this, he's learned something. And he can figure out a way to get this paid and caught up.
Here the judge takes on an almost mentoring tone. Instead of focusing purely on legal violations, he acknowledges that people sometimes make poor decisions under stress. Withholding rent, spending the money, and then facing eviction is a situation many tenants unfortunately experience. The judge seems to recognize that the tenant's behavior may have come from frustration and uncertainty rather than bad intentions. That perspective opens the door for a possible compromise between the landlord and tenant. And that's exactly where the judge directs the conversation next.
Right now, in my estimation, is an opportune time to try to arrange to do that because we're at the beginning of the month and we don't have September clicking. So here's what I'm going to ask you to do. Go out, talk to the landlord, see what they're willing to do for you, and give them a proposal as to how you're going to get this paid off and caught up. Okay? All right. Why don't you go?
Clarify what is in escrow right now.
I have 1050 twice.
Okay.
Is that right? Is that what you?
21.
Yeah, about 21. Is that what you have? You didn't make a payment in August, sir, did you?
No.
I've got 2 payments. One on.
I'm sorry. I'm not doing it.
You're not finding any? No. I got.
777.
Probably a lot. They should have 2 payments.
2100.
Yes, 2 payments at 1050. That's what we get. All right. McMahon, go out and talk with them. All right. See what you can work out. Remember your end goal.
Yes, Your Honor.
All right. Thank you.
By the end of this hearing, the judge has steered the case away from an immediate eviction ruling and toward negotiation. The landlord has a legitimate claim for unpaid rent, while the tenant has raised concerns about past maintenance issues and financial hardship. But the judge makes one thing very clear. Denying access for repairs and spending withheld rent severely damaged the tenant's legal position. Instead of issuing a judgment right away, the judge encourages both sides to step outside the courtroom and discuss a payment arrangement. If they can reach an agreement, the tenant may still have a chance to remain in the apartment while gradually paying off the overdue rent. What cases like this highlight the delicate balance housing courts must maintain, protecting landlords' rights to collect rent while also recognizing the human realities behind housing disputes. And now, we want to hear from you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.